Welcome to this Introduction to Criminal Justice course. I am Professor Darrell Ouellette, and I'll be lecturing today on the Criminal Justice Decision Network. This will be lecture 5, and in this lecture I'll be discussing the decisions made in whether to charge someone and who makes that decision. I'll also be discussing the process of investigating crime, deciding whether to charge someone with a crime, the evidence needed, and I'll give a brief overall view of the charging decision and the process involved in bringing the accused to court. We'll be discussing the arraignment process, the scheduling for trial. It'll be a brief overview. I'll talk much more on that later on in the course when I lecture on trial procedures and the court process. The role of the prosecutor, sometimes called the district attorney. The district attorney is an elected official, and each county of every state has an elected district attorney. This is a person who has the ultimate say as to whether someone will be charged with a serious crime. The district attorney usually has a staff of other attorneys that assist him in making that decision, as well as assist him in, or her, in prosecuting crimes. The Criminal Justice Decision Network, the center of that network is the police officer and the prosecutor or district attorney. Again, the decision to charge someone with certain crimes is often left up to the individual officer early on in most investigations, but the ultimate decision rests with the prosecutor in major crimes such as felonies, and I've included here murder, arson, rape. The thorough investigation of a crime by police is what determines which charges will be brought against a suspect by the prosecutor. In a major crime, the prosecutor may want to review police reports before a decision to arrest is made. Once again, I'm showing you the criminal justice funnel. I've already mentioned how types of crimes committed, crimes reported, crimes investigated by police. Now we're getting to the point where we're actually arresting a suspect and charging that suspect. I will not get into the actual trial process, but I will explain what leads up to a trial, the court process in which someone is brought before a judge to answer the charges they've been arrested for. Now, in every crime, you need to have evidence before you charge anybody with that crime. The types of evidence needed is often either physical evidence or testimonial evidence. Identifying a suspect comes as a result of what evidence is uncovered, and how that evidence may link a suspect to a crime scene. Once again, CSI TV shows have gotten everybody's interest, and it shows the importance of what physical evidence found at a crime scene can link a suspect to a crime. So evidence is often physical, but it also can be testimonial. Physical evidence is defined as any evidence that is tangible, which means that it has substance to it, where it can be touched or picked up as a whole or partial form. Testimonial evidence is evidence that comes from the spoken word, such as testimony from a witness. Now, the criminal justice decision process normally begins when police set out to investigate a crime, either because they have received a report that a crime was committed, or because as a result of indirect evidence they believe that a criminal act has taken place. If police discover that a crime has occurred, their next action is to determine who the perpetrator was and apprehend the individual. This, of course, is the what we call the arrest decision. After an arrest, the individual is taken into custody and booked. That is, the arrest is registered in a police station, and the suspect is fingerprinted and photographed. The next step in the investigation process is what we call in-custody investigation, which, among other things, involves an interrogation and may require the suspect to appear in a lineup, physical lineup. That is, they'll appear on a stage with persons of roughly similar appearance for viewing by victims or witnesses to a crime. Now, physical lineups are not used as much today as they have been in the past. They're used more in a large city where you have a larger sample population, where they can select at least 6 individuals to stand on a stage. These individuals all have to be of the same race, same sex, approximately same height, and like appearance. When a physical lineup is not used, then we use what we call a photo lineup. Same process occurs there. You have to use photographs, whether they be all color or all black and white. Again, they have to be the same general description. And the photographs are shown to a witness, and the witness may select who the suspect of a crime is. Discretion is a major component of whether someone is going to be arrested or not for a crime. Discretion is the flexibility that a police officer has as to whether to charge someone with a crime. The law allows some flexibility. Most often, any discretion used by the police officer occurs when the officer is dealing with minor crimes, such as motor vehicle violations, infractions. As the crimes get more serious, such as serious misdemeanors or felonies, then that discretion is no longer available to the police officer. The law only allows a prosecutor or district attorney to decide whether or not a charge will be brought against someone. Once the decision is made to arrest someone, then the police officer will take that person into custody. In custody means that the person's movements are restricted. An arrest is an official seizing and detaining of a person by lawful authority. The charging decision is the glue that holds the entire criminal justice system together. The charging decision is often complicated. It transfers suspects to defendants. It transfers defendants to convicted offenders. It transfers defendants to probationers or inmates, and possibly to parolees. So once a person is charged, he now becomes a defendant. He was a suspect. Once he's arrested or charged, he becomes a defendant in a courtroom proceeding. And then once the trial has occurred, the defendant may become a convicted offender. And then a sentence will be passed on or passed out to that offender. Person may do jail time or pay a monetary fine or be placed on probation, what have you. Now, once again, police investigate crimes. The arrest decision is made or case is brought before a grand jury. The prosecutor can also request a probable cause hearing before a judge instead of a grand jury. The grand jury process was a process that was put into place so that people were not arbitrarily arrested just because the police officer did not like them or the prosecutor did not like them. A grand jury was put into place so that there would be fair treatment of everyone and people would not be wrongly charged of a crime, especially if there was no evidence. A grand jury is a group of citizens who meet to investigate charges coming from preliminary hearings. Even though you've been arrested for a felony, it doesn't mean that other people will not look at the charges against you and also decide on your faith. Again, it prevents corruption by power or hungry prosecutors or police officers. It was put into the system to ensure fairness for everyone. So a group of citizens, your peers, meet to listen to the evidence from the police officer, the prosecutor, and they take a vote to see if there is enough evidence for someone to have been charged with such a crime. Once the grand jury decides whether or not there should be a charge, the suspect is taken into custody and booked. So a suspect can be taken into custody and booked either by an arrest decision, but ultimately a grand jury will also look at that at your case in a serious crime. If no grand jury is sitting, the prosecutor may decide that the case will be brought before a probable cause hearing. Now, a probable cause hearing is similar to a grand jury hearing, except a judge hears the evidence to determine if enough to charge a defendant. The other major difference is that in a grand jury, only the police officer presents the evidence, whereas in a probable cause hearing, the defendant is allowed to sit in at the hearing along with his lawyer, and they're able to question any witnesses brought forward. Grand jury, a group of citizens make a decision whether to charge you, In a probable cause hearing, the judge is the one who makes that decision. Very similar. Now, after an arrest, if the suspect cannot make bail, then the suspect must be brought before a judge within 48 hours for an initial appearance. Again, the initial appearance is before a magistrate or a judge. Both mean the same, magistrate or judge. And this appearance is to determine if the alleged crime was committed and if this person could have done it. The district attorney gives a summary of the evidence against the subject and how it was determined that a crime was committed by this suspect. Now the judge will will decide if he will lower the bail if the person cannot make bail, or keep the person in jail. If this was a very serious crime like a murder, most often no bail will be allowed. If there's enough evidence to charge someone with murder, that person will have to await their trial while sitting in jail. The judge will not usually allow bail on a murder charge. On a lesser charge, they probably will decide on bail. Now, if the person could not make bail during the initial arrest, the judge may decide to lower the bail so the person can get out while awaiting trial. Now, in the charging decision, the police reports go to the district attorney for a decision whether or not to charge someone and what to charge someone. The defendant is now the suspect is now a defendant. The district attorney may bring formal charges in one of two ways. Either the evidence is brought before a grand jury without the defendant there. The DA gives evidence and asks the grand jury to give an indictment. An indictment is a formal charging document. The other method is that the district attorney can go before a judge. This is what we call a probable cause hearing, and the defendant and the lawyer may be present during the probable cause hearing. During this hearing, the district attorney will give evidence and ask a judge to formally charge the defendant, which is and the end result is the same as an indictment. But prior to any of these occurring, a police officer has the authority to make an arrest even before evidence is brought before a grand jury or a probable cause hearing. And in that arrest, there'll be an administrative recording of an arrest where a person will be arrested. They'll be given a charge of what the arrest was about. They'll be fingerprinted. They'll be photographed. The police will also do an in-custody investigation, such as an interrogation or a lineup, whether that be a physical lineup or a photo lineup. The interrogation, that is defined as the skillful questioning of a suspect. Now, once a person is arrested by the police, or the person is formally charged through a grand jury or a probable cause hearing, that person must make an initial appearance before a judge. And the judge will decide on bail or jail, and the judge will also decide on the possibility of a court-appointed attorney. The definition of bail is a monetary guarantee deposited with the court to ensure that defendants will appear at a later stage in the criminal justice process. So the initial appearance, again, it could come as a result of a person being arrested by a police officer for a serious crime. It can be as a result of a grand jury coming down with an indictment, or an indictment coming from a probable cause hearing. So 3 ways a person can be charged. Again, if the charge comes directly from the police, then a grand jury or probable cause hearing will need to take place anyway to reaffirm that there is enough evidence to bring someone to trial. Arraignment. Definition of arraignment is a pre-trial stage to hear the information or indictment and to allow a plea. Now, an arraignment comes after the initial appearance. Arraignment is when someone actually will need to, they've been formally charged, and they will need to make a decision as to whether they will plead guilty or not guilty. The initial appearance was only to determine bail and whether a person will make bail or not, and the person will be read the charge. The arraignment comes later because the person will need to make a decision whether they'll want an attorney and whether they'll make a plea of guilty or not guilty. So, initial appearance would be the first stage, pretrial stage. Arraignment would be the second part of the pretrial stage. I'd like to talk a little bit now about pleading and trial. If a plea of not guilty, then a judge will schedule a trial at a later date. Once a trial date has been set, this is when the clock starts ticking as far as Speedy Trial Amendment, which is the 6th Amendment. If a plea of guilty is made, a date is scheduled for sentencing. If a plea of not guilty by reason of insanity, then a mental exam is ordered on the defendant. During the trial, if the defendant is acquitted, which means that he or she is found not guilty, then they are able to walk out of the courtroom as a free person. If during trial, if the defendant has pled guilty, then the person is convicted by plea, and the defendant is returned back to court later for sentence. During the sentencing phase of the court process, a judge listens to both defense attorney and prosecutor for recommendation of a sentence. A pre-sentence investigation is ordered, and sentences vary. A person could get a monetary fine for their crime. They could be ordered to do community service. They could be ordered to go to jail or prison or probation. The pre-sentence investigation, this is a process where a probation officer will be asked to look into a person's past. If a person is found guilty or pleads guilty, the pre-sentence investigation, this is the stage where any prior convictions, any prior criminal record, that information is brought to the judge. The person standing in the community, whether the person is working, whether the person has good standing in the community, this is all taken into consideration when a judge decides on a sentence for the crime. Probation can be a sentence outside of prison. A person can be just given probation rather than a prison sentence. Okay, let's review what been mentioned so far in this lecture. Once again, the ultimate decision to charge for a crime rests with the prosecutor. That's important. A prosecutor is called a district attorney. This is an elected office at the county level. The decision to charge occurs after a review of a comprehensive investigation by the police. The DA will look at the police report, will talk to the police officer, and the DA has the ultimate decision as to whether a charge will be brought on the individual. Even though that individual may have already been charged by the police, the DA has the final say as to whether those charges will stick. Arrest on felonies must later be reviewed by a grand jury or a judge at a probable cause hearing. Even though a physical arrest has already been made, that evidence will also be reviewed by either of those bodies, a grand jury or a probable cause hearing. Once formally charged, the defendant with a lawyer is brought to court for arraignment. Now this is where the charges are read and the defendant is asked to plead to them. Again, if not guilty plea, a time and place for trial is set, and the defendant is either released on bail or given personal recognizance or returned to jail. If a plea is guilty and it is accepted by the court, then the defendant usually is given a date for sentencing sometime after the pre-sentence investigation is conducted by a probation officer and reviewed by the judge. Sometimes special pleas, such as not guilty by reason of insanity, are allowed. This would bring about a mental exam. Of course, if there's a plea of not guilty, then a trial is scheduled. After trial, if the defendant is found guilty, sentencing occurs after a pre-sentence investigation by the probation officer. Here again, the judge listens to the defense attorney and to the prosecutor for a recommendation as far as what the sentence will be. And sentences in general may vary from place to place, and they also vary on what types of sentence. Again, there could be a money fine, it could be hours of community service, it could be jail for so many days up to a year, or prison for a year or longer. If the person is placed on probation, there may be conditions of probation. Probation can be is a sentence outside of prison. The conditions and rules of probation are set by the court. And those could be, usually they're a curfew where a person has to be at home by a certain hour every day. There will be conditions such as no substance abuse, no association with criminals. They must keep their whereabouts known to the probation officer. They must otherwise behave themselves. Sometimes they're required to have a job. And there are special conditions that are sometimes attached, such as making restitution or seeking professional help. Now, if there's any violations of probation, that is a cause for revocation, and the person may be sent off to prison to do time or go back to prison if they've been let out early. And that sums it up for this lecture. Have a good day.